Madame la Présidente, les années se suivent et se ressemblent. Chaque année, à pareille époque, le ministre des Finances nous présente son Finance Bill. Un Finance Bill qui, au fil des ans, est devenu un véritable fourre-tout. Malgré le ruling du Speaker d'alors, en date du 21 juillet de 2009, et les standing orders que, Madame la Présidente, vous-même, vous avez bienveillamment cités, force est de constater qu'une fois de plus, dans ce projet de loi devant nous aujourd'hui, il y a plusieurs amendements à des lois qui n'ont absolument rien à voir, ni de loin ni de près, avec les finances ou les taxes. Un exemple, les amendements au Clinical Trials Act. Certains amendements, Madame la Présidente, mériteraient un texte de loi séparé, avec un débat spécifique sur la question. Et je suis sûr, si on avait un projet de loi séparément pour la GRA ou pour le NIC Act, il y aurait eu plusieurs intervenants sur le projet de loi. Toujours est-il que, Madame la Présidente, nous nous retrouvons aujourd'hui avec un Finance Bill qui contient des amendements à pas moins de 56 textes de loi dans un document long de 147 pages. Mais je dois souligner que le Premier ministre a fait un effort cette année. On demande seulement 56 textes de loi, alors que le Finance Bill de l'année dernière, on a demandé 57 textes de loi, dont un de moins, c'est toujours cela de gagner. So much for the form, Madam Speaker. Let's turn to the substance of the bill. I'm not going to go through every single amendment that is being proposed in the Finance Bill. We already had a thorough debate on the budget speech. What I propose to do is to limit myself to the few specific amendments which either has not been dealt with at all during the budget speech or had not been dealt with sufficiently in the budget bill, and which is now before the House. I will start with the Public Debt Management Act, and I entirely agree with the Honourable Leader of the Opposition that we should have had a separate bill before this House dealing only with this very important piece of legislation. As announced in the budget speech at paragraph 339, the Public Debt Management Act is being amended to change the method of calculating the public debt ceiling. This amendment is welcome. It's welcome because for a number of years now, we on this side of the House have been criticizing the government for artificially defining a mode of calculation of public debt which does not, in fact, reflect the reality of the situation. For example, for the purpose of calculating public sector debt ceiling, we don't take into consideration debt of banks and insurance companies owned by the government, which is not guaranteed by the government. Similarly, certain debt incurred by certain enterprises are not within the definition. So, the new method of calculating public sector debt is an improvement, but still not entirely satisfactory. Honourable members will recall how the Honourable Prime Minister, in a joint press conference with the Indian High Commissioner a few months ago, explained that the billions of rupees of loan that we will be getting from the government of India so generously will not form part, those debt will not form part of our public sector debt for technical reasons. For technical reasons because of special purpose vehicle which be issuing preference shares. I think, Madam Speaker, that it is a responsibility of every responsible government not to understate our public sector debt. And this government should certainly not be bragging about the fact that it has found means to borrow money without affecting our public debt ceiling, and it should not be claiming trademark, copyright on doing so. Because at the end of the day, Madam Speaker, it will be us, taxpayers, who would have to repay all these public debt. Madam Speaker, in the budget speech, the Honourable Prime Minister also vouched to reduce gross public sector debt to GDP ratio to 63% by the end of June 2018, and then to bring it back to 60%. I'm afraid, Madam Speaker, but when it comes to reducing public debt, this government has been a serious underachiever. A serial underachiever. We will remember how in 2014, when this government took office, the public debt was at 61% of GDP. The Honourable Minister of Finance vouched to reduce it to 58.6%. Instead of it being reduced, it was increased to 61%, and then to 66% last year. So 61% instead of the promised 58%. Up, up, and up. This is why when it comes to public debt, Madam Speaker, I call this government a serial underachiever. Yet under Section 9, subsection 3 of the Public Debt Management Act, the minister is required under the law to prepare a debt management strategy, and from time to time to review that debt management strategy. Now, does this government have a debt management strategy? If it does, then obviously the strategy is not working. Madam Speaker, there is no harm in borrowing to finance expenditure, provided that the borrowing generates growth from which we can repay our debt. But the public debt is growing higher today than our economic growth. And we know that this government will not be able to reduce the public debt. And this is why, in the proposed amendment before this House today, government is only required to reduce the public debt ceiling to 60% by the 30th June 2021. Not by next year, not by the following year, but by 2021, meaning after the mandate of this government is over. Quel aveu d'échec! Après moi, le déluge. What they were promising, and when you think about that this government was promising a second miracle économique, and they're not even able to reduce our public debt. That's why I call them serial underachievers. Madam Speaker, with your permission, I would like to say a few words about the introduction of this tax agent. This has been hinted in his speech by the Honourable Leader of Opposition, and then in detail by the Honourable Shakil Mohammed. And I have to come back to this because I'm very disappointed. I've listened carefully to the Attorney General, who is also the Vice President, the Vice Chairman of the Motion Bar Council, and serious issues have been raised about the right of lawyers to represent taxpayers, and he did not mention anything about it, except that he mentioned that the Honourable Prime Minister would be explaining the rationale behind this. So let me state how the situation is presently. Today, any taxpayer who wants to go before the MRA, who wants to go before the Assessment Review Committee, can be represented by a counsel of his choice. The counsel goes there because we are law practitioners, we are licensed to provide legal advice, and we have free right of audience before all court. What is being proposed now is that not only accountants, but also law practitioners, barristers, will have to register as tax agents. And this is not what was said before. When we look at the annex to the budget speech, Madam Speaker, at page 13, under registration of tax agent, this is what it says. As part of efforts towards modernization of tax administration, the Mauritius Revenue Authority Act will provide for registration of tax agent with the MRA. A member of the Mauritius Institute of Professional Accountants and a member of the Bar Council will be deemed to be registered. This is what was announced, that as a member of the Bar Council, we are deemed to be registered. Automatically, we don't have to do anything, we are automatically registered as a tax agent. But when we look at what is proposed in this act, in the Mauritius Revenue Authority Act, at page, amendment to the act, at page 80, if I'm not mistaken, of the finance bill, what we see at section that there is going to be a new part 3A. Section 17C, no person shall represent a taxpayer before the authority, shall represent the taxpayer before the ATA panel, before the Assessment Review Committee, unless he is registered as a tax agent. Then section 17E, no person shall be registered as a tax agent unless, and there is a criteria. Subsection 2, any person who wishes to be registered as a tax agent shall make an application to the Director General in such form as may be approved. Choosing who can represent a taxpayer against him, in absolute breach of all rule of natural justice and fairness. He is the judge and party. And the Honourable Attorney General doesn't say a word about this, not a word about the constitutional right of any person to be represented by counsel of his choice. Because we know when the taxpayer is dealing with the MRA, there may be penal sanctions. There may be criminal liability if the taxpayer has breached the provisions of the Income Tax Act or the VAT Act. So now, in order to negotiate with the Director General will decide who can appear before him. So I would respectfully ask the Honourable Prime Minister not to move for the amendment of the MRA Act. Take the time to consider and talk to stakeholders, and at the very least, provide what was provided in the annex to the budget speech, meaning that any law practitioner automatically is a tax agent, which is not the case the way the proposed amendment to the MRA Act is structured currently. Moving to the Income Tax Act. One of the highlights of the budget speech, Madam Speaker, was the introduction of the negative income tax, which was welcomed by both sides of the House. And I'm not going to open the debate on the impact of such measure on minimum wage, or whether this measure should have covered part-time workers or people in the informal sector. Suffices to say that unlike what Honourable Minister Gayan stated in his speech, these measures relating to negative income tax will not ensure that every worker in this country will have a minimum salary, because this is very specifically directed to certain type of full-time employees whose employer are paying the national security. Now, one aspect of this law, Madam Speaker, which seems to have escaped the attention of all the members addressing this House before me, is the proposed amendment to the amendment that has been circulated yesterday. Now, if we look at the finance bill, the section dealing with operation, commencement of the Act, section 61, subsection 12, tells you that section 26, ZC, 26ZK, 26ZR shall come into operation on 1st January 2018. And Section 26ZK and ZR are the section of the Income Tax Act dealing with the Negative Income Tax Act. So we were told in the Finance Bill that this provision will come into effect on the 1st January 2018. And this is what was in the budget speech. This is what was in the annexes. However, yesterday, an amendment was circulated, and in paragraph E of the circulated amendment, we note that in clause 61, by inserting after subsection 3 the following new subsection, subsection 3A, section 26 ZK and ZR shall call into operation on a date to be fixed by proclamation. And subsection 12, which provided that the clauses will come into operation on the 1st January 2018, has been deleted. So we await impatiently for the Honourable Prime Minister to explain why. Is there a reversal of decision? Are we to take it that the measures announced in the budget relating to the negative income tax will no longer take effect on the 1st of January 2018? And if not, when? When will these negative income tax measures come into force? Madam Speaker, when the Honourable Prime Minister was referring to the negative income tax measures, he stated in his budget speech that these measures was being introduced to reduce income inequality. And he also announced another measure to reduce income inequality, the imposition of a solidarity levy. So that certain individuals who own more than 3.5 million rupees will have to pay 5% additional tax. However, what the Honourable Minister of Finance did not mention in his budget speech is that in the Finance Bill, he will be introducing other measures which would have the opposite effect. Instead of reducing the income inequality, it will actually increase the income inequality. And there are, if you look at the Income Tax Act, I'm not going to go through every measure, you have a number of tax breaks, tax rebate, tax exemption, which would benefit only a specific class of taxpayer. For example, there's a generous 8-year tax holiday afforded to companies involved in deep ocean water air conditioning. And we all know, Madam Speaker, that up to now there's only one company in Mauritius who have received the license to do deep ocean water cooling. But more importantly, Madam Speaker, I would like to talk about the decision to reduce the income tax for export-oriented companies. You would recall, Madam Speaker, that in his budget at paragraph 55, the Honourable Minister of Finance stated, and I quote, "I'm introducing a major tax reform to encourage our domestic enterprises to expand their export capacity and seek new markets, especially the SMEs. Their profits," meaning the SME profits, "their profits from export of goods will be taxed at the lower rate of 3% instead of 15%. So, Madam Speaker, we are reducing the income tax rate from 15% to 3%. That's an 80% reduction in the tax rate. So I was expecting these measures to be limited to SMEs, because this is what the Honourable Prime Minister said in his budget speech. But when we look at the Finance Bill, the situation is different. When we look at Section 44B of the Income Tax Act, this is what it says. Where in an income year a company is engaged in the export of goods, it shall be liable to income tax at the rate specified in Part 2 of the third schedule, which is 3%. Section 44B does not talk about SMEs. It talks about company. Any company who is exporting goods will pay only 3% tax. And we all know, Madam Speaker, who are the companies who are involved in the export? The SMEs? No. The SMEs are mostly for locals. Who are the big owners? Who are the owners of the big textile factories in Mauritius? Who owns the manufacturing plants in Mauritius? Who owns the sugar factories in Mauritius? Les PEP. 100 rupees negative income tax for les PEP. Hundreds of millions of rupees, if not billions of rupees, in tax rebate to sugar barons and textile tycoons. Is this how this government intends to reduce income inequality? By giving generous tax rebate to those who are already rich and already can pay more income tax? It is clear, Madam Speaker, that a shareholder of an export-oriented company will be now better off with the measures announced in the finance bill. Fair enough, it is going to pay 5% additional tax on its revenue, but as a shareholder, change. When they have the possibility to put into practice whatever they were saying in the opposition, what do? They do exactly the opposite. Madam Speaker, it is worth reminding ourselves what Honourable Pravin Jagnnath said when he was in opposition, and then see what he said when he was in opposition, and now what he's doing when he's in power. In a press conference which he's given, and on the picture we can see there was Honourable Vice Prime Minister Sudan and Honourable Boda, who was by his side. That was a press conference on the 29th of September 2013, reported in Weekend newspaper, and I'm going to table a copy of the compte rendu of the press conference. This is what he said. The title of the newspaper was National Identity Card Scheme. Pravin Jagnnath accuse Navin Ramgoolam d'avoir mis en route une machinerie infernale. First of all, Honourable Pravin Jagnnath accused the former government of surreptitiously amending laws relating to the national identity card. He is reported to have said in that article, and I quote, « Vous fin dire qu'il fin comploter froidement depuis quelques années déjà. Et en catimini, fin faire un amendement à National Identity Card Act, the Finance Act 2009. So, Honourable Prime Minister, then a simple member of the opposition, went to the press and criticized the government for bringing amendment to the National Identity Card en catimini through the Finance Bill of 2009. And today, what are we doing? Are we doing the same thing? In the 150 pages, buried in the 150 pages, aren't we amending the National Identity Card Act, the NIC Act? Isn't that doing it in catimini, like his predecessor? Shouldn't the proposed amendment to the identity card, such an important amendment, not be the subject of a standalone bill, where I'm sure many people of this House would have had a chance to voice out their concern? Second thing which the Honourable Pravin Jagnnath said in that press conference is that he objected to the fact that the Civil Status Act had been amended to provide for the recording of such other particulars as may be prescribed. He is reported to have said, and I quote, such other particulars as may be prescribed. Ça capable n'importe quoi. In other words, he was against giving power to the minister, giving him the right by regulation to prescribe what information may be put on the national identity card, because it can be anything, n'importe quoi. And he was right. Fair enough. You should not give a blanket check to the minister to put whatever he wants. But what are we doing now? Section 5 of the NIC Act is being amended to provide, and I quote, subsection 2, every identity card issued in respect of a person shall contain, in electronic form or otherwise, the civil data of the person, the photograph of the person, the date of issue, the address of the person, the signature of the person, and, subsection F, such other information as may be prescribed. Isn't that exactly what you said 2 years ago in the press conference? That it means n'importe quoi, that you were against it, and then today in power, you do the same thing. You give the power to the minister by regulation to put any information on that card which the minister by regulation may want. And that's not all, Madam Speaker. In the same press conference, Honourable Pravin Jagannath also warned against the people who may have access to personal data when he's reported to have said, and I quote from the same article, la police, ICAC, et même pas de ministre capable d'avoir accès à une information extrêmement sensible qui concerne un individu. Quand nous prenons tout ça là ensemble, nous trouvons qui manière machine-là fin mettre en place. So he was against the police, ICAC, ministries having access to sensitive personal data. And again, let's look today what he's doing with the bill. We are repealing and replacing Section 10 of the NIC Act. We're introducing a new subsection 10, subsection 3, which contains the following position. Without prejudice to the generality of the power under subsection 1, the minister may make by regulation, in particular, to provide for the levying of fees and charges, to prescribe card readers, to prescribe SAM cards, to authorize entities to use readers and read civil data electronically from identity cards, authorize entities to use card readers equipped with SAM card to read addresses and photograph electronically from identity card, and authorize entities to use, solely for the purpose of identification, such devices as may be prescribed equipped with SAM card to read fingerprint image, which I understand will be deleted in the amendment, to read fingerprint minutia electronically from identity card without copying or storing such data. So under this section 10, subsection 3, Madam Speaker, we are giving power to the Honourable Minister of ICT by regulation to prescribe who can use a card to read the data that is stored on the NIC card. So now, not only the police, not only ICAP, not only ministries, but anyone which the minister wants will be having this machine and will be able to read your sensitive personal data. And I say anyone because, although this is not in the bill, when we look at the annex to the budget speech at page 41, section C7, is clearly stated the National Identity Card Act will be amended to allow reading card data by both public and private agencies, as may be determined by the Ministry of Technology, Communication and Innovation according to set criteria. So now this government is going one step further. Previously, they were criticizing the then government, which will allow the card to be read by ministries, ICAC, and the police. Now they're going to give powers to the minister to prescribe, to allow private, not only government-owned entities, private entities to read the data stored on your identity card. And you can imagine, Madam Speaker, the horror among the population, especially among the militants who had fought so hard against storing of data on the national identity card when they read the proposed amendment. Let us not forget, Madam Speaker, that there has been a constitutional challenge to the NIC Act. There has been a case that went all the way up to the Privy Council. People out there are genuinely worried about the national identity card being misused. People out there are worried that their card may be stolen, and once stolen, may fall in the wrong hands and may be misused. They have read articles in the internet. I have read those too. And despite whatever reassurance which the Honourable Minister Swaminathan has given us in his speech, the fact is that according to reports on the internet, fingerprint minutiae can be reconstructed into fingerprint images. This is what the internet articles, which I've seen, which have been circulated, says. So they are worried, Madam Speaker, that despite that the law provides that there would be, that the card will only read those information, they are clearly worried that there is not sufficient safeguards. There's not sufficient safeguard to ensure that there would not be collection of data, storing of data, and misuse of data. And let us not forget also, Madam Speaker, that before the Privy Council, in the case of Mahadeo and the state, at page 11 of the judgment, Counsel for the State informed the Privy Council, and I quote, "The government had not issued card readers which would give access to the minutiae on the chip." This is one of the arguments used by Counsel for the State. Now, if Counsel for the State had informed the Privy Council that the government is going to come and give card reading machines to the private sector, maybe the outcome before the Privy Council would have been different. We don't know. But be that as it may, I have absolutely no doubt in my mind that there would be challenges to the national identity, the proposed amendment to the NIC Act if the government insists on going ahead with this bill. In his injunction case, Madam Speaker, the Honourable Pravin Jagannath, the counsel for Honourable Pravin Jagannath, stated that he was not contesting the verification functionality as opposed to the identification functionality. If the Honourable Pravin Jagannath, before the court, stated that he didn't have any problem with the card machine, with the card being read for identification purposes, so why today we are going to add information on this card which has nothing to do with the identity of the person? We've heard the Honourable Minister talk about e-health, about medical reports on that card. We heard him say about, civil data, about proof of address on that code. Now, just imagine this card falling in the wrong hands, Madam Speaker, I can find no better words, Madam Speaker, to describe the danger of the proposed amendment to the NIC Act than use the very word which Honourable Pravin Jagannath is reported to have used and reported in Weekend newspaper on the 29th of September of 2013, and I quote, "La carte sous lentilles contient un chip qui sert à inscrire des renseignements de base pour chaque citoyen. Ça provient un instrument politique terrible dans la main d'un gouvernement travailliste pour faire harcèlement, victimisation et prosécution, prévient-il. Toute qualité de dominaire et persécution, Ramgoulam pour capable faire avec l'information qui peut aller au nouveau code d'identité, il y a un danger, c'est qu'il peut faire. C'est un tyran, un dictateur capable d'agir de la sorte et qui, à cause de ça même, il félicite Mugabe." Madam Speaker, les paroles s'envolent, les écrits restent. Today in government, whatever the Honourable Pravin Jagannath has been saying against Ramgoulam, against the Travaillists, he's doing exactly the same thing today. Exactly the same thing that he was reproaching the members of the government when he was in the opposition. It is for this reason, Madam Speaker, that I would urge the Prime Minister to withdraw this amendment, hold consultation with stakeholders, come up with specific amendments, instead of giving powers to the ministers to prescribe what information can go on that card. Already set out what information. If you want to limit it to e-health, already provide that is going to contain this information. Don't leave it open, because people out there will no doubt bring a constitutional challenge to those proposed amendments. Madam Speaker, the one but loss provision of law which I want to tackle is a proposed amendment to the Gaming Regulatory Authority Act. Honestly, I'm not an expert in gaming. I don't know much about horse racing and never took any interest in it. However, when I was required to intervene in this finance bill, I had to make some research on the GRA Act. I had to go through all the PQs and PNQs that has talked about this and read the Commissioner of Inquiry on horse racing and meet people in the sector. And what I found was clearly horrifying. Horrifying, Madam Speaker, nothing less than horrifying. Today, in this provision, in this finance bill, we are going to amend the GRA Act. And the amendment will serve two purposes. One, the first purpose is to shift the balance of power between the GRA and the horse racing organizers, the Mauritius Turf Club. And then the second purpose would be, as I will demonstrate later, to unreasonably favor one specific operator, one specific bookmaker. Now let's come to the first purpose, which is to change the balance of power before the GRA and the Mauritius Turf Club. I listened carefully to the Honourable Anil Gayan. It is not true, Madam Speaker, that this Act is implementing the recommendation of the Commissioner of Inquiry. To say the least, Ms. Anil Gayan has been economical with the truth. What the Commissioner of Inquiry on horse racing recommended is the setting up of a Mauritius Horse Racing Authority, independent of the Gambling Regulatory Authority, not to give more powers to the GRA. In fact, the Commission of Inquiry has been extremely critical of the GRA. And I find it very disturbing, Madam Speaker, that when we're bringing an amendment which is going to affect the Mauritius Turf Club, and I'm declaring I'm not holding any brief for the Mauritius Turf Club, I find it very disturbing that yesterday, in a communiqué issued by the Mauritius Turf Club, the Mauritius Turf Club stated that il est regrettable que la MTC, qui a initié et fait perdurer les courses hippiques depuis plus de 200 ans, n'a à aucun moment été consultée par rapport à ces changements. Very regrettable. We are going to provide amendments which will directly affect the way MTC operates, the way it levies charges. It's going to affect directly its operation and finances, and no one has found it fit to come and deal and talk to the MTC and find and take on board whatever they have to say. So the first proposed amendment to the GRA Act is to allow the GRA to, in section 32, to allow the GRA to approve rules of racing and any amendment thereto. So previously, the MTC, as a private club, was governed by its own rules. All its members had to adhere for these rules. Now, the GRA has the power to approve and not approve the rules. So that's deliberate interference by the GRA in the internal running of the Mauritius Turf Club. Then the GRA will have the right to review decision of horse racing organizers, even decision of the appeal committee. Today, if you have a jockey who has not ridden the horse the way he should, there is a procedure for sanction, and there is also an appeal procedure under the aegis of the MTC. With the proposed amendment, the GRA will now have the power to reverse the decision of the MTC. So the jockey who is not satisfied with whatever sanction is taken by the Mauritius Turf Club we can very easily go to the GRA and have the decision overturned. Now, I don't have a problem per se with giving powers to the GRA. If the GRA was manned properly by fit and proper person. But let us see what the Commission of Inquiry had to say about the GRA at paragraph 10 and 11 of its executive summary. The Commission found that the GRA to be not fit for purpose and required fundamental changes in leadership, operational strategy, and crucially, proper resourcing with experienced and motivated staff and better technological support. That recommendation is borne out by an almost unanimous opinion from all evidence given to the Commission that the GRA is an ineffective and inefficient organization, in spite of the fact that the Gambling Regulatory Authority Act 2007 provides excellent statutory backing for the authority. So what the Commission of Inquiry is telling us is it is not good enough to have good laws. It is not enough to give all these good provisions, all these powers to the GRA. You need first to ensure that the GRA is effective, is efficient, is fit and proper. And yet, Madam Speaker, not a word, not an amendment being proposed today in the Finance Bill that is going to improve the way the GRA is run, to make it more efficient, to make it more fit for purpose. And we all know, Madam Speaker, and I'm not going to delve lengthily on that, that today the GRA is manned by political appointees with their own agenda. Now, the Honourable Prime Minister, in presenting the amendment to the GRA Act, stated that the Act is being amended, the proposed amendment is mainly aimed at curbing money laundering through gambling activities. That is the official reasons why we're amending the law, to curb money laundering through gambling activities. But, Madam Speaker, the Financial Intelligence Unit for and Anti-Money Laundering Act already provide that operators of casinos and bookmakers, being members of a relevant profession, have a duty to ensure that the people who are betting with them are not using proceeds of crime. They already have a duty to ensure the true identity of the people dealing with them. They already have a duty to report any suspicious transaction. All the measures to curb money laundering are already there. Now, whether the bookmakers are not applying the law as they should be, that's a different matter. There are sanctions to be taken against them. But it can't be that we are doing the amendment just to curb money laundering. And what is the amendment that is being proposed? What is being proposed is that henceforth a person cannot put a cash bet in excess of a prescribed amount. In the annex to the budget speech, there was no prescribed amount. It was stated 2,000 rupees. You could not place a bet in cash for more than 2,000 rupees. In the proposed amendment today, the figure 2,000 has been replaced by such amount as may be prescribed. So maybe in his summing up, the Honourable Prime Minister will let us know whether he has another figure in mind instead of 2,000 rupees. Next, there is a confusion whether the placing of bet relates only to placing of bet with bookmakers, or does it also cover someone who goes to a casino to bet, to play? And I have to say, it is not clear, the way I read the Act, whether the placing of bet include placing and playing games in the casino. And I agree fully with the Honourable Leader of the Opposition that the measure introduced to require a limit on cash betting is not going to curb money laundering, but in fact is going to increase illegal betting. We're going to increase illegal betting by credit. And already the Commission of Inquiry has stated that more than 800 million rupees annually is lost in tax revenue through illegal betting. So, Madam Speaker, if the purpose of amending the law will not have a significant effect on illegal betting, why are we amending the law? And this is coming to what I consider to be the real reason before the amendment. The real reason before the amendment, Madam Speaker, is to favor one specific organizer. Today, all bookmakers are allowed to take only cash bets. They can't take any bets other than cash bet, except for one. Only one operator today can open an account for a player, get that player to put money on that account, and then every week use the account to make bets. So for me, there is no doubt that by requiring all players now to open a player account, this amendment is unreasonably favoring the one operator who has the software, who has the know-how, who has the ability to provide a player card account, which is SMS Parias. And this is not the only instance, Madam Speaker, where the GRA Act is being amended to favor that one particular operator. Section 33 of the GRA Act is being amended so that it is the board of the GRA will now determine how much a bookmaker, how much SMS Parias will have to pay to the racing organizer. You will recall, Madam Speaker, that on the 18th of April 2017, Honorable Rajesh Bhagwan asked a specific PQB 230, on the dispute between SMS Parias and the Mauritius Turf Club. And this is the crux of the proposed amendment. There is a dispute between SMS Parias and the Mauritius Turf Club as to how much money SMS Parias has to pay Mauritius Turf Club. So the Honourable Prime Minister stated that the GRA issued a directive to the Mauritius Turf Club to require the Mauritius Turf Club to charge only a certain amount, the low amount, obviously, from SMS Parias, until, and I quote, until a complete review is carried out. The actual wording used in the directive, as quoted by the Honourable Prime Minister, was pending a holistic review of the terms and conditions under which charges are paid pursuant to contracts under Section 33(1) of the Act. And the Honourable Prime Minister added, to address this issue, the Gambling Regulatory Authority is commissioning an independent report on the charges imposed by the Mauritius Turf Club. So clearly, when we came to Parliament and asked the question, Honourable Rajesh Bhagwan asked the question, the Honourable Prime Minister stated that the GRA is commissioning a report. And one newspaper, the Mauricien, of 10th May 2017, even mentioned that course hippique, license fees, l'arbitrage de BDO, l'incontournable BDO, pour le litige SMS Parias MTC. So clearly, based on what the Honourable Prime Minister has stated in this House, we were expecting that there would be a full report on how much money MTC has to charge SMS Parias and other bookmakers, and then, once we are given the report, from then the law can be amended or not. But without waiting for the report, without waiting for the holistic review of the terms and conditions, today we are asked to amend the law and to make it law that it is now the GRA, the board of the GRA, which will fix the amount payable by SMS Parias to MTC. This is what we are asked to do, Madam Speaker. We are not asked to make laws. We are asked to resolve dispute between Mauritius Turf Club and SMS Parias. This is what we have been called to do. Amending the law so that GRA will now determine what amount SMS Parias will pay to Mauritius Turf Club. Now, this is not our role, and we all know where GRA is going to side. But let's look closer, Madam Speaker, at what we are amending. What Section 33, subsection 2 is telling us. The GRA is, Section 33.2 provides that where the bookmaker has paid the fees fixed by the GRA. So once the GRA say that SMS players must pay X amount to Mauritius Turf Club, the horse racing organizer cannot prevent the bookmaker from using the race cards and fixtures of the Mauritius Turf Club. Now, this is very innocent. I'm sure a lot of people, including myself, did not understand the reason for this amendment until I was enlightened by people in the field, people who do bookmakers and who knows what is going on. This amendment, Madam Speaker, is anything but innocent. What this amendment says is once GRA tells MTC how much money SMS players must pay to MTC, SMS players can use freely the fixtures of Mauritius Turf Club. Freely in Mauritius and outside of Mauritius. You can take bets on that. And in order to brush aside any doubt as to whether the GRA is able to do this, there is a specific amendment in this Act. Section 6 of the GRA Act is being amended to provide that one of the functions of the GRA is precisely to ensure that once a horse organization like MTC has been paid its fees, it cannot prevent bookmakers from using its fixtures. So that is the extent we are going today to help one particular operator, SMS Players, against Mauritius Turf Club. Why? To understand this amendment, Madam Speaker, we have to travel back in time and look at what is happening, not in horse racing, but in football betting. There is a company which is called Sport Data Feed Limited. This company, Sport Data Feed Limited, claims that it has exclusivity to use fixtures of football, English Premier League football. So what this company has done, it has entered a series of cases in court against a series of bookmakers, preventing them from using the fixtures of the Premier League, so that these competitors, the bookmakers, cannot offer bet on the outcome of English Premier League. And he won these cases in court, injunction. And again, I don't know if it's a coincidence or not, one of his lawyers was Mr. Colin Dalilou, who is not here. So, in the case of football betting, we have judgment saying that it is the owner of the fixtures who will fix the price. And we're talking about big money, Madam Speaker. I was actually very shocked about the type of money we're talking. We're talking, for example, Data Feed Limited is claiming fees amounting to 4% of the gross stakes on bets. 4% on all stake that they receive. Huge money, huge sort of money, just to use the fixtures every week, information about which football team is playing against which football team. 4% stake. So when it comes to football betting, GRA doesn't intervene. Sport Data Feed can impose whatever things he wants. He can prevent whatever bookmaker from using the fixtures, prevent them from competing with him. There, GRA finds no problem when it comes to football betting. But when exactly the same thing happened with horse betting, when the holder of the copyright in the fixture, MTC, is concerned, here, no. GRA will not allow MTC to charge the fees that MTC wants. Why? Because GRA now is going to side with the operator, with SMS Players. And when we know, and that is the shocking part of it all, Madam Speaker, the same people who are behind SMS Players are also behind this company, Sport Data Feed Limited. Voilà aujourd'hui le niveau de ce Parlement. Voilà ce que ce gouvernement est en train de faire. Sous le gis de 150 pages du Finance Bill, on est en train d'amender la loi, taillée sur mesure, pas pour les copains-copines, mais pour un opérateur. Et la population a le droit de savoir de quel côté ce gouvernement est, avec qui il est. Madam Speaker, the last point that I will talk about is the Commissioner of Inquiry Act, the proposed amendment to the Commission of Inquiry Act. I've saved the worst for last. Madam Speaker, I commend the government. I think that probably the best decision that this government has taken in the interest of one and all is to set up a commission of inquiry on drug trafficking. Because every day when we read newspaper, all of us are horrified by the extent, the tentacles of the drug traffickers, the extent of the involvement of the police, of the involvement of the prison services, of the involvement of the lawyers, of the barristers, who, by reading on the press, act more like accomplices rather than as legal advisors. But for the Commission of Inquiry to work, to be effective, it has to be able to get information. It has to be able to get confidential information which otherwise they would not be allowed to get. And this is the purview of Section 11, subsection 5. Section 11, subsection 5 provides that, notwithstanding any other law in force in Mauritius, where a commission requires, in relation to a matter of vital public importance, specified in the 4th schedule, the full disclosure of bank accounts, bank deposit of a witness, including any account or deposit operated or made by that person in a fictitious name, so not just his name, but as a prénom, or for or on behalf of any other person, not just his account, every bank which is required by the Commission to make the disclosure and which fails to do so shall commit an offence and shall, on conviction by the intermediate court, be liable to a fine not exceeding 1 million rupees. The 4th schedule, Madam Speaker, concerned unlawful possession or dealing of dangerous drugs, unlawful possession of or dealing in dangerous weapons, wealth and riches unlawfully accumulated by fraud and corruption. So these specific provisions of the law requiring banks to disclose information is only applicable in 3 circumstances where you have commissions of inquiry dealing with drug trafficking, with dangerous weapons, or dealing with wealth accumulated by fraud. So it doesn't concern, for example, the commission of inquiry on horse betting. So it's very specific, very narrow. And what the law says is one of the sanctions, if you don't give me, if you're a bank, and you don't give me the information, you don't give the commission of inquiry the information requested, the bank can be prosecuted. The bank can be fined 1 million, but more importantly, under subsection B, section 11.5b, the intermediate court may, in addition to the fine, order the license of the bank to be revoked. This is a very drastic measure, I agree. But, Madam Speaker, this is a drastic measure in exceptional circumstances. This is where you have a bank which is deliberately intruding, preventing the Commission of Inquiry from working. Such a bank do not deserve to have a banking license. If such a bank is hiding the banking transaction of drug traffickers or armed traffickers, of fraudsters, of course they are not fit and proper person to hold a banking license. Of course the intermediate court should be able to revoke their banking license. And yet, in these provisions of the law, the Honourable Prime Minister is telling us to delete that, remove the power which the intermediate court have to sanction a bank who is not cooperating, to sanction the bank who is not providing information to the Commission of Inquiry. And to justify this, this is what the Honourable Prime Minister said. Technical amendment will be made to the Commission of Inquiry Act to align it with the Banking Act. But this is not a technical amendment, Madam Speaker. The Banking Act is one thing. If you have breached the banking provisions of the Banking Act, the central bank can deal with you, can call you, can fine you, can revoke your license. Here we're talking specifically if you're not providing information which you have to provide to the Commission of Inquiry. And if you're not providing it, the Commission of Inquiry cannot act, cannot do its work. So, Madam Speaker, I'm very troubled by the timing of bringing this amendment. We are bringing this amendment to curb the power of the intermediate court to sanction a bank who is not cooperating at a time when people of this government have been criticizing the Commission of Inquiry. people of this government have been putting improper motives on the Commission of Inquiry, have been talking about the Commission of Inquiry doing a mud-singing exercise, talking about the Commission of Inquiry being biased and not calling certain lawyers because apparently they refer work for arbitration, which in my opinion amounts to contempt. So, Madam Speaker, when we look at all this taken together, I will make an appeal to the Prime Minister not to delete the sanction, which is going to be used only in exceptional circumstances to revoke the banking license of a bank which is not providing the information that it is required to provide to the Commission of Inquiry. Madam Speaker, I started my intervention asking the question, why do the Minister of Finance lump amendments to not less than 56 Acts of Parliament and come before this House with a certificate of urgency? Now we know, Madam Speaker. Government does that so that it can tailor-make laws to suit a selected few, and hope that the amendment, en catimini, to quote the Honourable Prime Minister, en catimini, would go unnoticed. And each time they will try to do so, Madam Speaker, we on this side of the House will unmask them and show their true colours to the people out there, so that the people can judge them by not what they are saying they're doing, but what they are actually doing. This is our pledge to the nation. Thank you.